to do this. The first time this happened has to do with the Kenya case, which I'll talk about in a moment. So those are the three ways a case can actually end up at the court. Right? There's also a layer with regard to jurisdiction. Right? Typically, a case is only going to go forward at the court if the crimes that we're talking about actually take place on the territory of a state party to the court, or was committed by nationals of that state party. The one exception to that is if the Security Council has referred the case. So that's how we see, arrest warrants out against the president of the Sudan for genocide, war crimes, and crimes against humanity, even though the Sudan has never ratified the International Criminal Court. Right. The United States, as a side note, is not a party to the ICC statute. The United States is afraid that it will end up, right, with its military being hailed before the International Criminal Court, and it does not want that. Right? The United States was quite happy to support tribunals for Yugoslavia and Rwanda and in other contexts, but when it comes to a tribunal that might actually apply to the United States, we have not only not ratified the treaty, but we actually signed it and then we took our signature away, which had never been done before. No one's even sure if that actually is a process at the UN. But we wanted to make sure that we were able to do what we could to undermine the treaty, so we took our name off it, which is kind of the first step of ratifying a treaty. As I said, the U.S. is worried that there will be this very politicized court that will go after U.S. nationals. That's not a particularly realistic worry when you think about the ways in which a case can end up before the court. Right? The one way that a state that's not a party can end up before the court is if there's a Security Council referral. Right? That's never going to happen for the U.S. because the U.S., quite conveniently, right, has a veto over any decision from the Security Council. So that's not a concern. Right? And there's jurisdiction only if we have a U.S. actor who commits the crime on the territory of another state party. Right? The concern here with the U.S. is that we do have the largest military presence abroad. And so they're afraid in humanitarian actions or otherwise, we might end up on the territory of a state that's a party to the treaty or says, well, when it comes to prosecuting the U.S., we'll agree to jurisdiction just for that purpose. Right? So the U.S. is worried about that. Right? The main thing that undermines this U.S. fear is this principle of complementarity. The ICC is supposed to complement, not supplant, national jurisdiction. So that means if a state is actually genuinely willing and able to investigate or prosecute a case, the ICC has no jurisdiction. So if the United States were to ratify the treaty, right, and the prosecutor managed to get pretrial chamber approval to go forward with the prosecution, the U.S. could block any prosecution so long as they actually genuinely investigate, prosecute, or decide that prosecution isn't warranted. The only issue that the U.S. Can validly raise with that is that it's the court itself that gets to decide whether a state prosecution is genuine. So if we actually have a very politicized court, then some of the U.S. fears are valid, but lately we've seen kind of a lessening of hostility. The U.S. at the Security Council has been more open to referrals and in fact actually supported the referral of the situation in Libya to the ICC. And moving to specific crimes, right? One example of the massive human rights abuses that have been criminalized in the civilian context, crimes against humanity. Right? So without trying to get into excruciating detail on this, I'm just going to quickly give you an idea of what a crime against humanity is. Right? It's a predicate act, which could cover a variety of crimes that we'll see in a moment. But let's take an act, for example, a murder. Right? If someone is murdered as part of a widespread or systematic attack against civilians. If that happens and the actor actually had knowledge that this attack was occurring, right, then that could constitute a crime against humanity. It has to be part of an attack, meaning it has to be multiple commissions of acts, it has to be widespread or organized, and it has to be through some sort of policy. Right? So just one person murdering another person will never constitute a crime against humanity. Right? It has to be in this much broader context. Right? Next slide will show the different predicate acts. So murder, I mentioned, it also includes extermination, enslavement, deportation, or forcible transfer, meaning the movement of a population either across borders or within the country. Imprisonment or other acts similar to imprisonment. Torture, of course, which is also criminalized in the Convention Against Torture. There are more. Next slide, please. So rape and other sexual crimes. This actually becomes important in the Kenya case because there were charges brought of both rape and other forms of sexual violence. In addition, in Kenya, for instance, there are charges of persecution. Right? This is something short of genocide, but similar to it. So acts that are being brought against a particular group because of that group identity, whether it be based on race or religion, ethnicity, culture, gender, etc. If it's on some sort of discriminatory ground, then it could constitute persecution. Other predicate acts, disappearance, apartheid, or our catch-all at the end. Anything that we haven't named, but that is equally serious and causes similar physical or mental harm. So that brings us to Kenya. Right? We know that there were massive human rights violations in Kenya, but do they actually constitute crimes against humanity? The background to this is the disputed 2007 presidential elections. Right? Here we basically had the ODM, the Orange Democratic Movement, with its candidate Raila Odinga, against the incumbent president, President Kibaki, who was part of the PNU, the Party of National Unity. And both of these political parties are heavily identified with certain ethnicities or certain tribes. So their political contest very much becomes identified with what tribe they're from. So we end up with the ODM, who is most identified with the Kalenjin and Luo tribes. They quote unquote lost the election. The election is disputed. Right? Kibaki controls the government says Kibaki won. Right? The ODM says no, he didn't, and launches a bunch of protests, but is also accused of massive human rights violations. In particular, the ODM is accused of crimes including killing. Hundreds of people were killed and hundreds of thousands were evicted on discriminatory basis. On the other side, with the PNU, who is identified with the Kikuyu, Meru, and Embu tribes. Right? So this group retaliates. Right? They see that their political supporters or tribal members are being attacked, right? And they retaliate against those who they think are their political opponents. So, overall, an investigation has showed that over 1,100 people were killed during this violence, and over 600,000 people were internally displaced. Both sides accomplished that internal displacement by working in gangs, going into a particular village, and routing people either by straight up violence, literally chasing them out of the town, or by burning down their homes and businesses, etc. Okay. So, how does this end up before the ICC? Well, after the violence, Kenya initially says, this time it's going to be different. We're not going to have impunity for these crimes. We're actually going to prosecute these crimes. And they said all the right things, but nothing actually got done on the ground. So the prosecutor of the ICC is watching all of this and is talking to the Kenyan authorities and saying, essentially, if you don't act, I will. Right? So he gives them a lot of time. It goes to the Kenyan legislature, and people there decide, no, we don't really want to set up a court in our own country to deal with this. Political stalemate, so the prosecutor says, all right, enough. I'm going to go ask the pretrial chamber to authorize me to do the investigation because you're not doing it. Right? And the pretrial chamber agrees. Right? First time it ever happened. Widely seen as a reasonable use of the prosecutorial authority, not politicized in any way. The Kenyans, however, are not pleased with this idea, right? Once the ICC is opening an investigation, they say, no, really, this time we mean it, we are going to prosecute, we will investigate. And so they go to the Security Council and ask the Security Council to use the other power it has with the ICC. I mentioned before that it can refer a case to the ICC, right? But it can also stop a case at the ICC for a year or more. Basically, if the UN Security Council says prosecution of this particular situation will be a threat to international peace and security, it can tell the ICC to stop in its tracks. So that's what Kenya asks, and the Security Council declines. They say prosecuting these top accused is not going to threaten international peace and security. We'll let the ICC go forward. So then Kenya does a formal admissibility challenge, right? Essentially, this is the formal version of, no, we promise, we really are investigating. Unfortunately, they didn't put any actual evidence in, right? They challenged admissibility, and if they had shown that they were actually investigating, the court would have had to stop. But instead, they put in a whole bunch of papers that said, yes, well, we're going to appoint someone to investigate this, and we're going to interview these people. And the court said, promises of what you're going to do in the future, not good enough. Right? We've heard that before. We can see the history of impunity in Kenya. We're not going to rely on that. Come back when you actually have something to show for your investigations. Right? So, Kenya loses the admissibility challenge, and the prosecutor's case goes forward, and he asks for a summons to appear. This is sort of the nicer version of an arrest warrant. Right? This basically says we have identified some accused, but we don't think that we actually have to arrest them and keep them in custody. We think that they will show up for the proceedings if we simply summons them to court. So that's what they did. And there were 6 defendants, 3 on each side, the prosecutor trying to appear as even-handed as possible. And the court allows the summons to issue. The pretrial chamber here actually consists of 3 people, and 2 people think, 2 of the judges believe that there's enough evidence to go forward. One judge, however, simply says there's not enough evidence of crimes against humanity. As we saw, for a crime against humanity, you have to have an attack, and that attack has to be part of a policy, and they say, no, not enough of a policy here. But that's just the dissent. Right? So the case does go forward, and there's a confirmation of charges hearing. Right? That's when the court reads an absurd amount of evidence from the parties. I had the pleasure of reading through all of those, binder after binder, from the parties, and then does an oral hearing, takes some testimony, and then decides whether any of the accused should go to trial. Now, unfortunately, my pictures are not showing those are not just blobs, but that's okay. You can imagine that these are three high-ranking, high-profile suspects. Right? We had two different cases, one for each side. Right? In case one, we have Mr. Ruto, Sang, and Kosgei. Right? To give you an idea of how high-profile a case this is in Kenya, Mr. Ruto is a politician. He is currently running for president. Mr. Sang is actually a media personality. He worked at a radio station, very key radio station in Kenya. And Mr. Kosgei is another high-ranking politician. Right? So for the first time, there are actual Kenyan politicians and high-profile people being prosecuted. Right? This simply does not happen in the ordinary course of business in Kenya. The judge that I worked for was hailed as a hero in Kenya because during one of the hearings, one of the defendants stood up and wanted to keep talking, and she said, no, all I wanted you to do was give your name, please sit down, and he sat down. And people in Kenya, I was reading the press reports, they were amazed like that she actually literally put a politician